Kia ora koutou, no mai haere mai ki tēnei kōrero or Indigenous rights. Ko Valmaine Toki a haungo ngāpui me Ngāti Wai. Hello everybody, my name is Valmaine Toki. I'm a legal academic heading of the Faculty of Law, the University of Waikato. I'm also a member on the United Nations Permanent Forum for Indigenous Issues. It's indeed a pleasure to be here, travelling many miles, but absolutely worth the travel. I'd like to take this opportunity to thank the Tom Lantos Institute, the University of Middlesex, and also the University of Public Service for this invitation to come and have a brief chat to you around the area of Indigenous rights. It's my very first visit to your most enchanting country, and I look forward to seeing more of Budapest. So today, as I mentioned, I'll be speaking to the topic of Indigenous rights, specifically the Indigenous rights movement, and also the Indigenous rights and the UN. So by way of outline, what I'd like to cover with you this afternoon is, first of all, provide some background, so the situation of Indigenous peoples, Oh, I didn't think I needed one.
But that's only for the record.
Right, okay.
Do you mind?
Do you mind it?
No, I'll just stay in one place. Might trip up, so I must leave it. Okay, so I might just backtrack a little bit here and again go through my outline of what I wanted to cover with you during this short time we have together. First of all, I'd like to provide a background with respect to the situation of Indigenous peoples, then start looking at Indigenous peoples and the United Nations. So a brief history of the movement and with some of the key actors identified that assisted moving Indigenous rights forward, the major objectives of this movement and also its achievements, culminating in, of course, the 2007 United Nations Declaration on the Rights of Indigenous Peoples, and also the formation of the United Nations Permanent Forum for Indigenous Issues as very much an Indigenous institutional structure within the United Nations. Moving on from then, I'd like to focus on the Declaration on the Rights of Indigenous Peoples. Why? Because this is the first international instrument that views these rights very much through that Indigenous lens, and what it provides is a clear articulation or manifestation of Indigenous rights. Now, the Declaration took some 25 years before it was eventually adopted by the General Assembly in September 2007. So I'd like to examine the major tensions within the movement during this time and eventually how they were overcome. Within the section, I'd also like to look at the intersection or the interaction between minority rights and Indigenous rights. So are there any overlaps? Are there any synergies? Are there any parallels, particularly moving forward? And I suppose the lawyer in me thinks, well, how can we be creative with our tools to realise the rights for minorities by using perhaps Indigenous rights as a case study or a benchmark to assist us with that process? Then I'd like to turn and look at my work, so my work within the United Nations and also my work at home in Aotearoa, New Zealand. There are some exciting initiatives that have been developed at home with respect to incorporating the Indigenous worldview within our criminal justice system that has actually led to the reduction of recidivism rates within the criminal justice system. And then, of course, it's always nice to end with some conclusions, reflections, and thoughts moving forward. So thoughts moving forward in terms of global minority rights and how you perceive them and how you would like them eventually realised or manifested in whether it's a policy document or whether it's an international instrument or some other forms of identification. Okay, so by way of background, there's approximately 370 million Indigenous peoples in the world. Their very survival continues to be critical. They face systemic discrimination and exclusion from political and economic power. They continue to be overrepresented amongst the poorest, the illiterate, the destitute. So, for example, in New Zealand, the death rates for Māori are still higher than those for non-Māori. You might also recall Professor Castellino's remarks yesterday when he clearly articulated those disproportionate social statistics for Indigenous peoples, and indeed using New Zealand again as a case study. Māori represent 15% of the population, and yet 50% of our present population identify as Māori. And if you're a woman, it's even worse because it's actually 60%, so there's a higher representation within our criminal justice system, specifically our prisons, of Indigenous peoples and women. Indigenous peoples are often displaced by wars and environmental disasters, and also dispossessed of their ancestral lands, territories and resources. So, for example, in Australia and New Zealand, the doctrine or the instrument or the doctrine of discovery was used by the colonising powers to assert sovereignty within those areas. And you might again remember that Professor Castellino yesterday referred to the term terra nullius. So that was, I suppose, a manifestation of the doctrine of discovery used by the colonisers to assert sovereignty within in Australia, the whole of Australia, and New Zealand, and Aotearoa New Zealand, within our South Island. In more recent times, moving forward, when we think about Indigenous peoples, we see their traditional knowledge, their cultural expressions, marketed and patented without their consent or indeed their participation. So, for example, the World Intellectual Property Office, which is a UN agency, is currently drafting 3 texts, one on traditional knowledge, one on traditional cultural expressions, and one on genetic resources. So you think, well, traditional knowledge, traditional cultural expressions, who would you imagine is a substantive, I never like to use the word owner, but where do the substantive rights lie if it's traditional? Then you think, well, it has to be with Indigenous peoples. Yeah, it makes sense, it kind of follows, and it's quite logical. However, the UN is comprised of states, right? Indigenous peoples aren't realised or recognised as a state within that process. So therefore, whilst this drafting of these 3 texts continues, Indigenous people sit on the sideline, unable to directly make any changes to that text because they are not states and they don't have that standing within the WIPO General Assembly to make those changes. How do they make those changes? They have to lobby states, get states to support their amendments to the text for the consideration of the whole WIPO General Assembly. And I think that's quite problematic for Indigenous peoples when their ownership, I suppose, of that traditional knowledge is usurped without any recourse or direct recourse that they can actually point to. When we're thinking about languages, we had a wonderful discussion this morning on languages. Of the some 7,000 languages today, it's estimated that more than 4,000 are spoken by Indigenous peoples. And language specialists predict that up to 90% of the world's languages are likely to become either extinct or threatened with extinction by the end of the century. So collectively, I think these statistics illustrate the grave danger faced by Indigenous peoples. So when we think about Indigenous peoples and the UN, I think understandably there remains a lingering frustration that the poorest of the poor, the most marginalised and discriminated against, still do not enjoy those basic or those fundamental human rights. And Indigenous peoples have historically appealed to the UN for some form of redress with respect to that breach of their fundamental human right. A couple of examples here. I have got one up here by Chief Descahay. So in 1923, Chief Descahay, the representative of the 6 nations of the Iroquois, what he did is he travelled to Geneva, to the then League of Nations, regarding a dispute with Canada over tribal self-governance. This was an abortive yet significant effort to secure a hearing with the League of Nations. So he leaves for Geneva in Switzerland to speak to the League of Nations in 1923 using only a passport. And I think this is quite interesting and very reflective of how proactive or how organised Indigenous peoples had, because he was travelling on his own passport from the Haudenosaunee Confederacy at that time. He presented what they call the Red Man's Appeal for Justice, and reminded the European colonisers of their obligations under the Two-Row Wampum, which is the most significant pact made between the Iroquois and the Europeans. So the grievance he sought was to resolve was the political turmoil and loss of sovereignty resulting from tribal governance under the then Indian Act. And the objective of this rather draconian piece of legislation, the Indian Act, according to Duncan Scott Campbell in 1920, was to do what? Was to continue until there was not a single Indian in Canada that has been absorbed into the body politic, and that there's no Indian question and no Indian department. So I think that's a very strong example of assimilation. So you can think back to Professor O'Leary's lecture there and sort of slot that into those theories that he presented yesterday. So despite Desgahay receiving the support of some nations, the British influence was too strong for any realistic chance at effecting change at the then League of Nations. He actually waited for a whole year to obtain recognition from the League and eventually returned home to North America. Although he was unsuccessful, he did sustain a remarkably successful PR campaign in Europe, where he found a much more receptive audience in the media and general public than he did amongst the delegation at the League of Nations. So remember the time frame against which this example is set against. It's a time when the League of Nations gave wide latitude to the states in their response to what they deemed domestic affairs. So a lot of support for the territorial right of states at the time. And remember, the genesis of the human rights and the Bill of Human Rights had not yet been proposed. So that's the backdrop against which Desgahay went to the League of Nations. Another example, one close to me, close to home in Aotearoa, New Zealand, was W.T. Ratana. He made a similar journey to petition the League of Nations regarding the Treaty of Waitangi breaches by the Crown, particularly, again, confiscation of land and land alienation. So if we just step back a little bit, and I'll just tell you a little bit about the treaty. The Treaty of Waitangi was an agreement entered into between the Indigenous peoples of New Zealand, Māori, and the Crown in 1840. And what that treaty guaranteed was certain rights and privileges to Māori. And what was happening is that the Crown wasn't adhering to those promises that were reflected within the treaty. So W.T. Ratana goes to the League of Nations to seek some form of redress with respect to those breaches of the treaty. So when you think about these two examples, both of these appeals did two things, or I suppose three things really. First, they involved Indigenous rights to the lands and resources, and two, both relied on treaties and pacts that were entered into with good faith by the Indigenous peoples to try and safeguard and recognise those rights that were intrinsic to Indigenous peoples. And thirdly, I suppose you can see that both of those plights were unsuccessful at the time. So initially, Indigenous issues received scant attention from the international community. This steadily changed through time, specifically the last 3 decades of the 20th century. In the 1950s, following concerns about the situation of forced labour among native populations, what this did is this prompted the International Labour Organisation to work on what became in 1957 Convention number 107, entitled, it's quite a long title, Convention Concerning the Protection and Integration of Indigenous and Other Tribal and Semi-Tribal Populations in Independent Countries. I don't know why they have such long titles for these conventions. Although this treaty was later criticised as being assimilationist, this eventually led to the adoption of the ILO Convention 169 in 1989, which you would be more familiar with. A great number of Indigenous peoples organisations was established at national and international level, moving through time in the 1960s and the 1970s, and this was very much spurred on by the whole decolonisation era and a more general growth in NGOs at the time. So although most of these activities of the important international Indigenous movement took place actually outside the environs of the UN, Indigenous peoples, you could see, were, I think, starting to be heard, and eventually the UN was finally starting to turn their minds or starting to listen to these voices of Indigenous peoples. Now, according to Professor James Anaya, now James Anaya was a special rapporteur for the rights of Indigenous peoples for the last 6 years. His term has just finished, and we have a new rapporteur, Vicky Tali Corpus, who comes from the same region as Rachel in the Philippines. So according to Professor Anaya, there were 4 aspects that contributed to this whole promotion and growth of Indigenous rights. He talks about the struggle, those 4 issues, the struggle against oppression or fascism. So moving through that continuum or moving through that timeline, you have after World War II, there's that greater support realised to protect minority rights with standards to resist racism and discrimination. We also now have that International Bill of Human Rights comprised of UDHR, the ICCPR, and of course the Covenant on Economic and Social Rights. He also points to that dismantling of European colonies, so decolonisation movement, awareness of cultural suppression, colonial suppression, and also self-determination, rights of self-determination and decolonisation. Now, as an aside, the UN actually has a decolonisation committee, and that decolonisation committee meets regularly at the UN. They consider the countries on the list of non-self-governing territories for consideration for their right to possibly succeed, seek independence from their colonisers. Now, of interest with that list is French Polynesia. So French Polynesia was originally on that list. They went taken off the list, and in very much a celebrated move, the General Assembly in May last year reinstated French Polynesia back on that list for non-self-governing territories. So that was only after intense lobbying by the Tahitians with respect to getting back on that list of non-self-governing territories. So therefore, the UN Decolonisation Committee can consider their application for possibly succession, possibly independence from France. I was actually in Tahiti when this intense lobbying was going on, and what was quite interesting at the time was you speak to the Indigenous peoples in Tahiti, and they're kind of a little bit nonplussed about whether they should succeed or seek independence from France. And because I'm an Indigenous advocate, I think, this is a fantastic opportunity. Not that you would necessarily want to succeed from or seek independence from France, but at least you have the opportunity to consider it. And so I think that's a good example of the mix or the opinions or the dynamics that are actually there on the ground in the flax roots in terms of whether Indigenous peoples want to indeed succeed or indeed seek independence from their colonisers. And I'm not saying that all Indigenous peoples have that perspective, but for me it was interesting speaking to the Indigenous Tahitians and them being actually quite frank in terms of their ambiguity towards independence from France. Arguably there might have been some agenda with respect to their response not wanting to seek independence, but nonetheless they actually quite a few people I spoke to did not want to succeed or seek independence from France. So going back to these 4 points that James Anaya suggested or articulated with respect to the growing movement of Indigenous rights, another point he mentioned was a failure of assimilation policies. So in New Zealand, the government proposed or implemented certain policies. A couple of them were pepper potting. So pepper potting is when you have a suburb or an area of European settlement, and within that area you place Indigenous peoples, and that's what they call pepper potting. And the idea is that from this policy that the Indigenous peoples will eventually become assimilated within the general European area. The other assimilation policy was language suppression. So my father, when he went to school, was caned or reprimanded for speaking Te Reo Māori or Māori language. That has now changed. Now, Te Reo Māori is an official language recognised in statute in New Zealand, and that's a positive step forward. And we also have our own Indigenous schools. So we have what they call a kura kaupapa, and that's an immersion school. So right from kohanga, or from kindergarten to middle school to intermediate, and then on to university or college, you have an opportunity to enrol your child into a school where you only speak your mother tongue. And it's really amazing, because my son went to a kura, and they teach three-dimensionally. So it's not like when you do your times table, it's like 2 times 2 equals 4, 2 times 3 equals 6, 2 4s are 8. And so it's a very lineal or two-dimensional way of learning, or rote learning. But in the kura, it's not 2 times 2 equals 4. It's like, well, you've got 2 and times 2, but how do we get to the answer? So you're using different pathways to solve a problem, and those pathways you use and you carry on to solve other problems. So it's not a rote learning way, it's more of a three-dimensional, holistic approach to learning. The fourth area that James and I talks about, he talks about this growing Indigenous middle class. So that's specifically the growth of NGOs. And even though globalisation led to the increase and the creation, and they've always been around, it was actually globalisation that was sent as a catalyst to do what? To increase their numbers, and particularly with respect to Indigenous NGOs. Moving through time, some more important milestones. In 1972, the United Nations Sub-Commission on the Prevention of Discrimination and Protection of Minorities launched a study on the problem of discrimination against Indigenous populations. This was later known as the Martinez-Cobo study, and this was the name of the special rapporteur appointed to prepare the report. At the same time, at the same sort of time juncture, the Indigenous, or the international Indigenous movement, was growing rapidly throughout the Americas, so Latin America in particular, the Caribbean, the Arctic, Australia and New Zealand, the Philippines and Bangladesh and elsewhere, and particularly with respect to the growing Indigenous NGOs being established. And the study on the problem of discrimination against Indigenous peoples, that created a momentum, and that momentum, together with the advocacy work of the Indigenous movement, led in 1982 to the establishment of the first United Nations mechanism on Indigenous peoples issues, namely the Working Group on Indigenous Populations. And this is actually, I think, one of those milestones with respect to reflecting on the growth of the Indigenous movement, because it was quite pivotal, not just in this work it was, but actually later on, which we'll look to when we look at the formation of the Declaration on the Rights of Indigenous Peoples. Between 1984 and 1993, Indigenous rights continued to gain momentum. So we have the UN Voluntary Fund being established in 1985, the adoption of the ILO Convention 169 on Indigenous and Tribal Peoples, the announcement of the International Year of the World's Indigenous Peoples in 1993, and the announcement of 2 separate international decades of the world's Indigenous peoples. The first decade was launched in 1994 and adopted the special theme of partnership and action. And this was to raise awareness about and also integrate Indigenous issues into the government's agenda. This first decade helped to promote awareness of Indigenous issues on the agenda of the United Nations, and also some of the agencies attached to the UN. At this time, Indigenous peoples themselves took advantage of this decade, documenting and providing information about the human rights violations. And what this did, it assisted to establish a place within various international fora. So not only did you have the establishment of these different mechanisms, the voluntary fund, the day, but you also have the Indigenous peoples at the same time being proactive in their own area. I'm just going to stop here, and if you want to stop me and ask any questions, please do so, because I like it to be as interactive as possible. And I know that sometimes once the point's passed, you don't revisit it. So please, if you want to ask a question at any time, please, I'm more than happy to digress from my prepared statement and answer your question, because I think that's a way to benefit more from this interaction. So please feel free to do that. So getting back to this first, yes, Russ.
Thanks. Could you talk a little bit about the process by which the ILO convention that you referred to is put together, as well as the UN working group? In other words,
Yep.
specifically, what role do the indigenous peoples play in the in making the document in the working group and so forth?
Well, the ILO, as the name indicates, is about labour and labour organisations and how that affected Indigenous people. So that is very separate to the Declaration on the Rights of Indigenous Peoples. However, in saying that, because it was labour orientated, you had more of a buy-in, I suppose, from NGOs, from states, with respect to the idea of labour issues. So I suppose you could say that took a different path with respect to the Declaration, because the Declaration is really focused on Indigenous rights, whereas the labour organisation, the ILO, is not. However, in saying that, people should still ratify the ILO. Some countries haven't ratified the ILO because it has quite strong rights with respect to Indigenous peoples. Yeah, and it's not a declaration like the Declaration on the Rights of Indigenous Peoples.
Right. And the working group?
The working group, they didn't have a stronger role to play with respect to the ILO. They were more convened under the auspices of the UN to promote Indigenous rights specifically. But in saying that, there were members of the working group that were quite proactive in the formation of the ILO, separately, individually. Okay. Any more questions, comments? Sure.
It is amazing for me to see all these bodies that have been set up and compare them with the minority
Yes.
minority rights bodies, and maybe you will tell us later on that, maybe you will explain to us later on how can it happen that by now we have a UN
Special
platform, UN forum for Indigenous issues, besides the General Assembly, while the UN forum for minority issues is still in Geneva. So all the Indigenous bodies are at a actually at the highest possible level in the UN. The Indigenous peoples have a voluntary fund,
Yes.
although there have been a decision for minorities to have a voluntary fund. It has never materialized. So both in numbers and the level at which the Indigenous fora are placed are much higher. So maybe you will want to tell us later on, perhaps why, how can you
Sure.
explain this big difference between the two
Sure.
movements?
Thank you for that question. It's a really good question, and it's one that I've been contemplating over these last 2 days, and I'll actually speak to that at the very end. So my idea is to try and pull some threads together, identify some commonalities, and try and be creative. So where that ends, I'm not quite sure, but that is my intention or hope. Any more questions, comments? Yes.
Could you speak a little bit more about on how to identify Indigenous peoples. I mean, now, past Indigenous peoples were considered as first inhabitants in the issue of aboriginality. And currently, for instance, in Africa, now the African Commission has given a decision that despite the issue of aboriginality, I think historical marginalization and isolation from mainstream activities of a certain sector of society could entitle a society to be considered as indigenous. So can you speak?
Oh, absolutely. I'm going to speak to the definition of Indigenous, and I'll also speak to the African situation in particular, as it pertains to the progress of the Declaration on the Rights of Indigenous Peoples, and how Africa kind of stalled that development and made some slight changes to the text of the Declaration moving forward. So I will actually speak to that as we come to it. Great. So going back to the first decade, there are a number of achievements. We have the International Day. We have celebrated on August the 9th, I think it is, so it's coming up very shortly. We have an International Day there. We have a special rapporteur on the rights of Indigenous peoples. We also have a fellowship program for Indigenous peoples established within the Office of the High Commission on Human Rights. And the other major goal of the first decade was the establishment of the Permanent Forum, which I'll speak to towards the end of my presentation today. We are currently at the end of the second decade. The second decade hoped to achieve five major objectives. So to promote non-discrimination and inclusion of Indigenous peoples in national policy, and also those legislative processes, effective participation in decision making, redefining policies to be culturally appropriate, strong monitoring mechanisms, and adopting targeted programs. So collectively, you look at all these positive steps forward for Indigenous peoples, and you think, well, this looks pretty good. You know, initially in the League of Nations, we had Descahe and Ratana going to the League of Nations, both of them being turned down, and then eventually through time, through all these different developments, you're getting more of a recognition of the rights for Indigenous peoples. Despite these important steps forward, a number of challenges remained, and most importantly was the lack of implementation by states of programs that promote the development and rights of Indigenous peoples, and the United Nations role in how to assist that to be realised. And indeed, moving forward, if I can just stray a little bit from my script, at the moment there's a World Conference of Indigenous Peoples, or otherwise known as a High Plenary meeting, that is actually going on right now, and that is to draft an outcome document with respect to Indigenous rights. A little bit problematic, I think, because again we have the states being involved in a document, which isn't such a bad thing, but the states thwarted the whole progress of this discussion. So you had the big states, Russia, India, Indonesia, saying, well, we're not going to engage in any further document that recognises Indigenous rights. However, in saying that, the President of the General Assembly managed to find a way through this impasse, and the process is happening now. And it'll be really interesting to see whether these struggles that Indigenous peoples have with respect to recognising these rights are actually realised within this high-level document that will eventually fall out of the General Assembly in September of this year. Yeah.
So this document, which is now being discussed by the World Conference,
Yes.
what would that be? A treaty, convention, declaration?
At the moment, it's just a statement.
Yeah.
So it won't have the same status as a declaration or indeed a covenant or convention. However, I'll keep you updated on that because it's still progressing. It's at a zero document stage at the moment. Yeah. So still challenges are lying ahead for Indigenous peoples, and primarily it's to do with the implementation of those basic fundamental human rights. And I suppose we look to the declaration for some hope in terms of meaningful realisation of those rights. So in doing so, a little bit about the declaration, the background. The declaration was seen as simply the most significant Indigenous milestone produced within the international arena. So for the first time, what we have are human rights being contextualised within the situation of Indigenous peoples, where those rights are made very clear and certain. Despite the significance of the declaration, the development was highly controversial. For some Indigenous peoples, the final draft or the final version or final text of the declaration was considerably weaker than what they wanted or what was envisioned. While for some states, of course, they said, well, these rights were too strong. So when we look at the right of self-determination and considering that Indigenous peoples thought it was too weak, the right of self-determination as provided for in the declaration only allows for internal self-determination, not succession. And Indigenous peoples during the drafting of the declaration said, oh look, no, we need succession. We need succession. However, their want was thwarted by the inclusion of Article 46, which clearly points to the respect for territorial integrity of the states, thereby, I suppose, thwarting any rights for external self-determination being realised by the declaration. So now the declaration only provides for an internal form of self-determination, which maybe not be such a bad thing. So thinking back to the Indigenous peoples in Tahiti, perhaps they would want just an internal form of self-determination rather than successional independence from France. So looking at the development of the declaration, it was the initiative again of the working group on Indigenous populations. So they were charged with a mandate to elaborate international standards concerning Indigenous people's rights. So we know this group was established in 1982, and the declaration was intended to fulfil the working group's mandate and provide a very clear articulation of international standards on the rights of Indigenous peoples. So they began drafting in 1985. It wasn't until 8 years later, in 1993, the working group completed a draft declaration on the rights of Indigenous peoples. A year later, the draft was approved by the subcommission, and in 1995, the Commission on Human Rights established a working group to examine and, I suppose, fine-tune the draft declaration. So the intention was to finalise this draft within the decade, that first decade that we mentioned in the front end of my presentation, the first decade of Indigenous peoples. However, state and Indigenous peoples very much, that politics stalled the progress of the declaration. And it was only after an extension of the mandate in 2004 that a reworded version was submitted to the Human Rights Council. Subsequently, it was accepted in 2006 and passed to a third committee, and it was intended that at that stage that the declaration would then pass to the General Assembly for voting and eventual adoption. However, the concerns of the African group stalled the progress in the final hour. So the African group during the whole drafting process remained mostly on the sidelines during the discussions. This was on the assumption, of course, that the declaration would have no application to them. But it was now really clear that the African groups were now claiming status as Indigenous peoples, and that they would now be under the scrutiny of the standards articulated or captured within the declaration. So, led by Namibia, they revisited some of those provisions captured within the declaration, and Mexico actually negotiated with the African states, and they were eventually satisfied by the amendments whilst not altering the substantive key provisions. So the African groups came out in the last hour and said, hey, you know, what's going on? This is going to apply to us. We need to turn our minds to it. So what they did is they changed very slightly some of the wordings of the preambular paragraphs and some of the articles themselves, not dramatically, but enough to appease them and then gain their support. But I suppose the lobby group was strong enough to stall the whole progress of the declaration at the 12th hour. So after this deferral and extensive lobbying, and we come to the final text, and so after 25 years of work, it was this very final text that the General Assembly adopted in September 2007. And the working group was then abolished at the time in September 2007, and it was replaced with the Expert Mechanism on the Rights of Indigenous Peoples, another body, Indigenous rights body within the UN. So when we're looking at so now that we've got the declaration, the final text being adopted by the General Assembly, the declaration, I think, is significant in three respects. First of all, the declaration provides Indigenous peoples with an international standard or benchmark to measure state action against. I think that's quite important when we're thinking about punitive actions or some kind of redress. You need some standard to measure any subsequent action against. Codification, so the declaration represents a codification of amalgam of rights that existed for Indigenous people. So it was all these rights within one place. And thirdly, it is the only international instrument dedicated specifically to Indigenous rights. And while the nature of the UN standard setting process requires some compromises, as we've seen, we just have to reflect on the 25 years it took for the declaration to be eventually adopted. For some Indigenous peoples, that compromise was far too great. Despite this, many Indigenous peoples, including Māori, accept the declaration and look to possible utilisation of those rights, those fundamental rights captured in the declaration within our own unwritten constitution. So when the vote went down in September 2007, it was passed by a majority of states. There were 4 major players that actually voted against the declaration, and they were Australia, New Zealand, the United States and Canada, so collectively known as the Kansas Bloc. And what New Zealand said is they said, well, we can't possibly support a declaration that provides Indigenous rights to lands, territories and resources. And we can't support a declaration that provides rights of free, prior and informed consent. So therefore we're going to vote against the declaration. However, in New Zealand we have legislation that arguably already provides for free, prior and informed consent. We have a Resource Management Act which contains a fiduciary duty to consult. So arguably that's already taken care of. And we have a Waitangi Tribunal that provides for some redress with respect to alienation of lands, territories and resources. So we're really questioning ourselves in Aotearoa New Zealand why New Zealand was reluctant to endorse a morally aspirational declaration and using those as an examples and stating that, well, these are fundamentally incompatible with our current legal system, so we can't possibly entertain the thought of formally adopting the declaration. And it wasn't until Australia reversed their position in April 2009 and they made a statement of support of the declaration that, in New Zealand we thought, oh, this is great, maybe, we'll change our mind. And it worked. A year later, almost to the date, April 2010, New Zealand made a statement also supporting the declaration, and that was made both on the floor of the General Assembly and also in our Parliament in Wellington. And then, of course, you only have two bad boys in the corner, Canada and the US, and they weren't going to be seen to be the last ones in the corner, so Canada jumps on and makes a statement of support of the declaration, and a month later the US makes a statement and says, yes, well, actually we support the declaration as well. So, it's peer pressure on a large scale, I suppose, with respect to that decision to change their mind to offer support to the declaration. So now that we have the whole Kansas bloc changing their mind and offering support for the declaration, you could say that, well, now it arguably has a more robust effect within the legal world, I suppose, because as a declaration we all know that it's morally aspirational, it's non-binding, it's soft law. However, you can be creative with this. You can use principles of admin law. You can point to case law that has used the declaration, and where judges have actually pointed to the use of the declaration. We have a little bit of case law developing out of Belize with respect to the declaration that we can point to. We can use the admin law principle of mandatory relevant consideration. You can use the presumption of consistency. You can use customary international law. So, even though the orthodox view is that it's only a declaration, it doesn't matter, you can't use it. As lawyers, and I heard today there are a few law scholars here, you have to be creative. You have to be advocate for your client and say, well, this isn't a closed door. We can work with this. We can be creative, and sure, it might not be the first tool in your toolbox, but it can support a submission or an argument for the recognition of Indigenous rights. And I suppose taking one step sideways, if you're thinking about minority rights, then why can't you use the same framework in terms of supporting minority rights and say, well, there is a declaration on minority rights, so why can't you use the same thought process with respect to advocating for those rights for the minorities? Anyway, just sort of going down off a bit of a track there. So, Indigenous. What is it to be Indigenous? Does anyone know? When you think about Indigenous peoples, what's the first thing that comes to mind? First Nations? Yeah, First Nations peoples? Absolutely. Absolutely. Are they the majority? Are they the original inhabitants? What do they look like? Do they have their own language? Do they have their own culture? Do they have their own dress? What is it? One or two things, or an amalgam of different facets? So there are different types of criteria which comprise what it is to be Indigenous. Well, the working group that we've been talking about, they said, well, it's descendants of the original inhabitants of conquered territories possessing a minority culture and recognising themselves as such. So that's one definition, if you like. But are they Indigenous peoples always the minority? In Aotearoa New Zealand, 15%, so we're definitely the minority. In Australia, the Indigenous peoples, 3%. In North America, 3%, possibly. So those examples are all minorities. Indigenous peoples are the minorities, right? How about Guatemala? How about Ecuador? How about our Latin American brothers and sisters? They are the majority. Indigenous peoples are the majority. And it's interesting because you look at Latin America, you look at Ecuador, for example, you look at Bolivia, for example, they are the majority. And their constitution actually has adopted articles within the Declaration of the Rights of Indigenous Peoples. The cynic in me says, well, because you have such a high percentage of Indigenous peoples, then they form the decision-making part of the political system. So therefore, their rights, or what they want to see in the Constitution, will be reflected. So therefore, you have those rights in Ecuador, the Ecuadorian Constitution, and also the Bolivian Constitution. Whereas in New Zealand, right, we're the minority, and we really struggle to have any rights clearly recognised within. We don't have a written constitution, it's unwritten, which makes it even worse, I suppose, but any form of right recognised there for Māori. So getting back to this definition of Indigenous peoples, This is this is a definition by Sha Zhang, the Undersecretary General for Economic and Social Affairs. And he talks about Indigenous peoples, they continue to suffer discrimination, marginalisation, extreme poverty and conflict. And you think, well, yeah, that sounds like it could be right. I know Indigenous peoples, they all seem to satisfy this definition from the Under-Secretary General. Now, does the ILO or the declaration itself provide a definition of Indigenous peoples? No, it doesn't. Which is crazy, you think. You know, you're a lawyer. You love definitions, right? You want definitions because they provide certainty. So you know that if you're Indigenous, you just have to go to the legislation and it tells you what it is. And if you don't satisfy that criteria, it's like, well, you're not Indigenous. It's really easy. But this document, the Declaration on the Rights of Indigenous Peoples that I've been talking about, this amazing document that took 25 years to develop to adoption, doesn't provide a definition of what it is to be Indigenous. How incredulous is that? Is that a surprise? Do you find that surprising? Well, oh yes. Thank you. Thank you. A really good question. The question I think posed is that, well, the declaration is only soft law. So even if there was a definition in any sort of interpretation session of the declaration, it's only soft law anyway, so it doesn't matter. Absolutely, but what if the declaration becomes customary international law? What if it becomes has a greater standing? Yeah. I mean, I know I have rose-coloured glasses. I know I'm a bit of a romantic, but still, you know, I think you have to be passionate about these things, right? If you're a lawyer, you have to advocate. You have to find a way through, and I think yeah. So yeah.
Is it not a concern that once you have a definition, it can exclude some groups who would like to qualify?
Absolutely.
And
absolutely.
Would you like to see that? Because obviously, any definition would facilitate the implementation of the declaration enormously, but it would have a very precise beneficiary. But at the same time, it would stop other groups to qualify or advocate for qualifying as Indigenous groups. So isn't that a dilemma?
Oh, absolutely, and a great question, and a question that has been asked by many people. So therefore, I'll just continue because I actually address that point there. So I'll just skip along. So this is another definition, and this is by that Jose Martinez Cobo, that special rapporteur that I mentioned at the front end of my presentation today. So he provided this working definition of Indigenous peoples, and I've highlighted their historical continuity, pre-invasion, pre-colonial. They form the non-dominant sectors. They're determined to preserve their culture and transmit it to future generations. So he provides that definition of Indigenous peoples. He actually goes on to elaborate and point to other factors such as occupation of ancestral lands, common ancestry, culture in general, language, residence on certain parts of the country, and other relevant factors. And also, this is quite important, he goes on to say that on an individual basis, an Indigenous person is one who belongs to these Indigenous populations through self-identification as Indigenous. So he's talking about group consciousness there, and is recognised and accepted by these populations as one of its members. So you get the flip side of that, and that's the whole acceptance by the group. And this preserves for these communities, that sovereign right and power to decide who belongs to them without external interference. So why wasn't there any definition provided in the declaration? Well, during the period leading up to the formulation of the declaration, the Indigenous organisations developed a common position and actually rejected the idea of a formal definition of Indigenous peoples that would be adopted by the states. And similarly, the states expressed the view that it was neither desirable nor necessary to elaborate a universal definition of Indigenous peoples. Because they wanted to leave it up to Indigenous peoples to articulate for themselves who I suppose would fall under that definition. And I don't know whether you think that's a cop-out or whether you think that's clever. I'm not sure. What do you think? I have my own thoughts on that. Is it excluding? If you have a definition, you have a right to exclude people who don't satisfy that definition, so you have that flip side of it. Yes?
I'm not disappointed by the fact that there is no definition. It's not the first time that in international law you don't have a definition.
Sure.
It doesn't mean this issue cannot be tackled. So there's no definition on national minorities, on terrorism, on
Sure.
Indigenous people. So it's not it's not a big deal, but you can still handle a situation like this. And as for something that Tana Maria was saying, it's not only about how to encompass all the groups within one definition to make it good. It's also how to encompass all individuals in that, and that's why self-determination and acceptance of this also come into play. So it wouldn't be easy to make up a definition that would be really encompassing and acceptable to everyone. That's why I don't think it is so necessary.
Thank you. Yes? Yes. So the comment is that I think minorities don't have a definition either, so therefore it's up to the states. The states can decide who are minorities because there's no clear definition. Yes. Mm-hmm. Do you wanna? I can't hear. I can't hear. There you go. We're tangled up, sorry.
Or maybe you can go there. After all this, you start yelling. Come on.
The main point is that without definition, I think the power to define or to consider or recognize a group as indigenous people or similarly minority shows minority is in the hand of the state.
Mhm. And do we want the state to define or determine who are minorities?
I think the best solution maybe is to be like European partners, because here in Europe when we talk about especially minority issues, we talk about successful example with shortcomings compared to American system of human rights or African system of human rights or generally even international. But no, I don't think this is a good idea just to give the definition or the criteria definition to states.
Right, so keep the definition within minorities. Yeah. And of course.
I'm getting
Yes.
so excited about it. Yeah, what I would like to say that there are several arguments for a definition, and I think because the Indigenous Declaration is quite unique in having been made by Indigenous peoples themselves, so the definition was drafted by Indigenous peoples, unlike any definition of minorities.
Mhm.
Minorities practically have not been involved in any documents or any international norms concerning them, or at least their involvement was very reduced. But this is a very different example because for years and decades it was the indigenous groups who crafted a definition. So I say once there is a definition which is more or less agreeable, go for it. Why? Because specificity of norms strengthens enormously any normative document. So if you have a definition made by indigenous peoples, you can apply to indigenous peoples. So I would have a strong argument for a definition.
Mhm.
Do you agree?
Yeah, I think it's really an interesting moot point that it'd be kind of nice to have a debate about, and because I think both minority rights don't have a definition, as well as Indigenous peoples Indigenous doesn't have a definition. So I think it'd be my geeky little world. I think it'd be quite interesting, knowing that the stakes are high. The right to be a minority, to be called a minority, the right to be called Indigenous, they're really high stakes because there are certain rights and responsibilities and duties that attach to being Indigenous and to also being a minority. I've just got a couple of other articles up there that allude to the fact that perhaps Indigenous peoples didn't want a definition of what it is to be Indigenous from the Declaration, which I won't actually go into. I think I'm a bit over time, am I? So I might just. Am I over time? For questions? I haven't finished. Talk too much. Here was I thinking I wouldn't talk as much. Okay, a few. So getting on to the idea of minority rights, Indigenous rights, are there parallels? Are there synergies? Do they overlap? Do they indeed intersect? So this is I think quite interesting. So thankfully, the former speakers have provided a very full dialogue with respect to minority rights. Suffice to say, I think minority rights are those rights ascribed to minorities to apply to ethnic, religious, or linguistic minorities. We look to the Article 27 of ICCPR that's been spoken to quite often by previous speakers, and also the Declaration as examples of documents that codify these minority rights, human rights standards. And indeed, before the Declaration, Indigenous peoples appealed to existing international instruments that included these minority rights for redress, and they actually became creative in the application or the use of those of those articles for Indigenous people, for minority rights. So specifically I'm thinking about Article 27 of the ICCPR and a general comment made by the Human Rights Council with, following an application by Indigenous people. So the comment 23 by the Human Rights Council actually managed to extend the reach of human rights to protect Indigenous people's land rights through that Article 27 of the ICCPR. And that's an example of being proactive. That's creative, with respect to what you've got. So Indigenous peoples relied on Article 20, this is before the declaration, relied on Article 27 that recognises minority rights and managed to obtain a general comment from the Human Rights Committee that extended the reach of that article to protect Indigenous people's lands rights. So that's, you know, that sort of sets a precedent, or something to be excited about, I think. So, parallels. What are the parallels? What are the similarities between Indigenous rights and minority rights? That's a question for you. It's funny when I teach, I often have silences like this, and I just wait until someone says something. Yes. Yeah, so great point.
Yeah, but so, and the question is what have Indigenous rights won and what they have lost, framing it that way.
So we shouldn't be looking at the parallels or the synergies, but also the divergence or the differences. Yep. That was going to be my next one. So if we look at some of the similarities, arguably both have been marginalised, both are vulnerable, both are disadvantaged, both don't have any definitions, yeah? Both have rights that are included, and yet both have rights which are included within a declaration, okay? And if we look at the differences, what are the differences?
Indigenous peoples have collective rights. That's an enormous
Collective rights, yeah.
internal
Internal self-determination, yeah, is available through the declaration. Internal self, absolutely. How about another difference? Yes. Yes.
I was wondering whether, for example, if we take into account the Rome Statute, international crimes, and such crime as genocide,
Yes.
whether we can say that Indigenous people can be target group because, as far as I remember, that it's a public international law, this genocide crimes, subjective element, with people, some particular social group with distinguished traits, features, and whether we can say that Indigenous people can be such group for genocide as crime.
Well, can Indigenous peoples be subjected
Yes,
or
that
to
is
genocide? Well, I think Professor Castellino gave a wonderful example of historical genocide of Indigenous peoples, the Australian Aboriginals in Tasmania. They were, they were completely wiped out. So, yep. Yes. Not so much these days, I don't think that happens, but that was quite a clear definition there. Yes.
You want to say no? Did you not want to make another point about maybe
Genocide?
Or genocide? So that was that they were both.
It's possible, but I don't believe that Indigenous. Again, I might be romantic here, but I don't believe Indigenous peoples will be subject to genocide. Oh, I shouldn't. Maybe they will be, but I live in hope.
Oh no.
Yeah. No. No? Not possible? Okay, so now we've identified the similarities and the differences. So where do we go from there? What do we do with that? What do we do with that? Does it turn on what you want to achieve, whether you want a minority right to self-determination, a minority right to your own language? Yes? So if the problem is that you want a minority right to internal self-determination, how do you achieve that? How do we achieve that through not so much the lens of Indigenous rights, but by considering the nuances of Indigenous rights and what they provide or what they can provide, or the vehicles or the framework? Do you think you can use that framework to realise internal self-determination for minorities? Is that possible? Or is that just a puff? How would you do it? Russ,
Well, I think there were, I guess, two
the
methods.
attorney.
Well, who hasn't looked at the underlying documents. But based on what you've said, I suppose you could try to argue that a minority at some point in time, somehow for some historic reason, satisfies the Indigenous definition, which isn't defined, and pull whatever rights are in that declaration, be covered under the Indigenous Declaration, even though they're sort of right now considering themselves a minority. And I suppose the other thing you could do in the longer term, what was a long-term political strategy, is to say if the Indigenous rights document has come after the minority document, that it's time to review the minority documents in light of these rights that are granted to Indigenous people.
Absolutely, and that's really clever because you're using two existing documents or declarations and sort of finding the windows or the similarities and pulling that. Yeah, that's great. What do you think about that? Isn't that cool? Aren't you excited?
But I think it has its limitations.
Yeah.
Because traditionally in the UN, I remember I went to the working group on Indigenous peoples, and obviously minorities there was a jealousy of minorities of Indigenous peoples, and there was also quite a distinction there, because it was feared that if the differences that were established between minorities and Indigenous peoples in the UN were to be diluted, then in self-determination, collective rights and self-determination would not be granted for Indigenous peoples. So I think that the definition of the Indigenous peoples were drawn up in a way that excludes minorities, for instance, national minorities, elsewhere. And it was very, very clear in the 100 years or so in the advocacy of national minorities that states were never, ever ready to grant collective rights or any measured self-governance. It was very clearly said by states that anything that begins with self cannot be codified, cannot be turned into a norm. And I think there are some concrete examples. For instance, the case of the Crimean Tatars, which is poor Crimean Tatars now in a Crimea made independent by Russia, or not independent, but
part of Russia.
Part of Russia.
It's not an act of self-determination there, surely, but you see, they are the only European example who try to qualify. No, the San people
Mhm.
are qualified as indigenous peoples, but the Crimean Tatars, and I don't think they've ever been accepted as an indigenous people, were they? I don't think so.
Well, the Tatars actually came to the forum.
Yeah. So
Crimean
they-
Tatars came to the forum
Yeah.
this year, and it was quite contentious because you know at the time had Crimea and Ukraine had just offered support for the declaration, and the Tatars were standing up and pleading, having their plight heard, and it was very contentious because Russia was standing up and saying, we're great, we do fantastic things, they're not what they're talking about. We have all these rights available for the Tatars, and of course, it's probably slightly, coloured their perspective, the state's perspective of how they treat the Tatars. But, sorry.
But I think that the issue in advocacy, in civil society movements, is that to what extent these advocacy or movements can be antagonized or separated, or to what extent they can weaken the rights. For instance, if minorities start grouping on the Declaration on Indigenous rights, Indigenous people's rights, whether they would weaken the chances of Indigenous peoples because states would be ready to lower Indigenous people's rights in order to not even consider collective rights for minorities. So there are all sorts of speculations, but I remember when I once had the opportunity to train in the UN with James Hanaya, and we trained both minorities. Within the decade of Indigenous peoples, there were 3 trainings organized consecutively for both minorities and Indigenous peoples. And this was in 2003, so the declaration was not ready yet, and there was tension between the two groups. And also Indigenous peoples were concerned that also about minority rights in the sense that will immigrants now be considered where they live more in compact areas? Would, for instance, immigrants, I remember one Indigenous person said, okay, so now would the Chinese be a national minority among us, a national minority among us? So I think there have been tensions, and then there can be tensions, and I think that national minorities in a way, or NGOs, tried to stay away from this movement in order to make sure that it succeeds. I think there was a kind of a tacit agreement that we don't go to that working group so that Indigenous peoples can get on and they can get. But I'm not saying this is a selfless thing, but it was a kind of a tacit understanding, at least within the UN. Is this not how you see it? Oh, I don't know.
I think it was probably politically astute to do that, so that, as you mentioned, Indigenous peoples could proceed with the formation of and establishment of the Declaration on the Rights of Indigenous Peoples. However, in saying that, before that we had the Declaration, Indigenous peoples relied on minority rights for, any sort of recognition or recourse. So you would think that there would be some kind of better relationship strategically, so that both Indigenous peoples could realise meaningful recognition of their rights, as well as minorities. And it's about being smart in terms of what you've got. So there is a special rapporteur on the rights of minority rights who's coming to speak to us on Thursday. So I would be using her to say, how can you help us because that's what she's tasked with. So it's about using those vehicles. But you want to know how they can work, support. It's just a way of lobbying. It's just a way of talking together. I would imagine.
I think there's another way that minorities can use Indigenous rights, that the literature, the interpretation, the reports on free, prior and free consent,
Sure.
on land rights,
Yes.
is enormous.
Yeah.
So the
Enormous.
interpretation that has been developed in the realm of Indigenous rights is just fantastically creative, and it's really an avant-garde way of using international law. And I think that's exactly what did not happen.
Mm-hmm.
You don't see, not even in the literature on minority rights in Europe, this kind of body of reports produced by your forum was used in a creative way.
Yes.
So I think, yeah.
Well, I know you're the special rapporteur. I know James and I did country reports, did visits, did took all sorts of complaints, and he was very proactive in supporting Indigenous peoples. And I'm sure this special rapporteur for minority rights would have a similar mandate. So it would be, the onus would be on her to assist in terms of writing reports on maybe getting research assistance to help with that, so that you can start establishing a body of knowledge or reports that can be helpful moving forward, I think. It was one of the questions I was going to ask you, actually. Was there?
Okay, is there somebody else over here that wants to speak? I just wanted to say that I agree very much with what she said. And I think what I'm about to say is probably a little bit controversial, but the problem with a lot of the differences between the perceived definitions, I think comes down to accepted knowledge of the difference between Indigenous people's definition of being conquered and minority rights as not being conquered, and then the entire encapsulation of conquering as being a notion of guilt in the international system, and access to land rights. Because when you remove the idea of land rights from this and the ability to create that collective self-governance associated with what has been taken from them, basically what Indigenous people and what minority rights advocates really want are a lot of the same things when it comes to culture. And I think that that's why there's such a big disagreement and why there's so much tension, is that because Indigenous people have been able to secure in a lot of ways on the international stage this idea that because they are conquered, they should have this right, where minority peoples have not, and are still being roadblocked on having collective rights and having access to territorial determination.
You actually mentioned a really important issue, and that is the idea of rights to lands, territories and resources. So Indigenous peoples have that intrinsic relationship with lands, territories and resources. So taking myself as an example, I am intrinsically related, connected to the land from which I came from, and that practice is reinforced by the fact that we bury our people there. We have our own forms of culture or tikanga around how we harvest fish, how we plant our crops, and that goes back mai rano for forever. So that relationship establishes those rights to lands, territories and resources, that's what Indigenous peoples have that minority rights don't necessarily have, or are encapsulated within minority rights, or they don't have that. So that's the biggest difference there. And so states want to have those resources, they want to have those lands, and so there is a proportionate or a higher degree of dialogue that happens with Indigenous peoples to try and secure that. Whereas with minority rights, that same, the lands, territories and resources, that facet isn't there for states to want to engage dialogue with them. Does that make sense?
Oh yes.
Yeah.
The same argument has been used in the United States and Canada over access to land rights, and for Indigenous groups in North America, access to land, both religious and non-religious, has been extremely argumentative, mostly because a lot of the tribes in the United States that have been able to pull themselves out of the crux of being trapped in poverty and alcoholism and undereducation and all of these types of things have done it through access to and control of the land for which they are on, whether it be religious or not, and they've used it economically for their benefit. So I think that while there are religious justifications across the board, a lot of times when it comes down to the actual economics in terms of working within the international system and working within the state, having any access or right to have claim to those types of resources is extremely important for groups.
Yep, I agree. Any more? Was there a question, comment there?
In Nepal,
Mhm.
all the indigenous people are minorities.
Yes.
All the Dalit are minorities.
Oh, do you want
And women also minorities. And some Brahmin Kshatriya people are not minorities. They are dominant.
to? Sorry.
All are
Yes, please.
In Nepal, all the indigenous people are minorities. Dalit also minorities. And women also minorities. These people defined by the constitutions, these are the minorities. And dominant peoples, dominant group, they call Brahmin Kshatriya, they are not minorities. They are Brahmin Kshatriya, and they are really nation. And when Nepal government ratified the Convention 169 and is a member state of UN, accept the declaration, UN Declaration of the Right of Indigenous People. After that, after going through the definition of these two documents, this dominant group start to misinterpret.
Mm.
We are also indigenous people. We have to get the right as indigenous people claim. They start to misinterpret it. This practice also happened in the Europe, America, and what about in the New Zealand? What about the implementation status of the Convention 169? Because New Zealand also ratified the Convention 169, right?
No.
No, not yet. So what about the UN declarations, UNG, implementation status of UNG? Thank you.
Okay. So New Zealand blatantly offered support for the Declaration on the Rights of Indigenous Peoples. However, in saying that, have they implemented those fundamental rights? Well, the government adopts the orthodox view, and they say, well, the Declaration is soft law. It's not. It's only morally aspirational. So even though we have offered support for the Declaration officially, we don't need to adhere to those fundamental rights within the Declaration. However, in saying that, there's our judicial bench is starting to use the Declaration in their judgments. So what I tell my students or implore my students to do is to use the Declaration in their arguments or their submissions in court, because the judge can't consider or use the Declaration in their judgment if they don't provide it or they don't argue it. So that's what I always say to my students. Okay. So I thought there was another question. Is there another question?
There is.
Oh, sorry. Yes.
Let me take like the no, it's okay. Let me take the questions like to a more of boring international law question, because like I believe rights of the indigenous as indicated in the instrument, or the possibility of like incorporating minorities under this declaration would rest in the normative value of the declaration itself. And it's unfortunate that the four countries has made a specific declaration, not supporting this declaration, the Indigenous Rights Declaration. And I think like the way they made the declaration is very problematic, because it's like the convention does not amount to a codification of customary law, nor does it indicate an emergence of a new rule of customary law. So it's not only not accepting it as it is, it shows some sort of not supporting it for its transformation into customary law. So
Yeah.
I'm thinking, how far is the impact of particularly the reservation of these four countries in enhancing the normative value of the declaration as a legal instrument?
Really good question. So, with respect to customary international law and the Declaration on the Rights of Indigenous Peoples, quite rightly, you mentioned that the Kansas bloc objected to or voted against adoption in 2007. Although that position has subsequently changed, if you wanted to use the doctrine of customary international law to make the declaration more meaningful or perhaps binding, you have the idea of the persistent objector, that they can say, well, actually, we've always, objected to the declaration. So how can you make use of what are there other ways?
Yeah,
That
and
you can make
particularly,
this-
what is the impact of particularly these four countries on making it, customary to even another countries? Because I believe these four countries can be good examples when it comes to the application of indigenous rights, taking into account particularly the existence of indigenous people in their domestic legal structure. But when they object to this document as an international legal instrument, how far it is impact, not only limited to them, but only in making it, in transforming it as part of customary.
I think that even though we have that idea of persistent objector and customary international law, that won't detract from other countries still applying the doctrine of customary international law to make those articles in the declaration more meaningful within their own national constitutions. That's what I believe. And even though we have that persistent objector provision, there are other avenues that you can use the declaration to make it more meaningful in terms of your argument. So you can use, if you're in a common law country, you can use case law, where judges have used the declaration to support a judgment that they've come up with. So there's a little bit coming out of Belize in particular. In New Zealand, there's some obiter dicta that refers to the declaration. So even though it's not substantive, it will come. And so that's why I implore my students to argue the declaration in submissions before the court. Because if it's not there, the judge can't consider it. Well, they can, but that's taking them out on a limb. And the more you use it, the more it becomes a matter of fact. A bit creative and a bit left-wing, but yeah. Okay, well, can I just finish off with my work? I know that it's really... Should I finish? Should I finish?
Yeah.
Okay.
Yeah, I think you can go. Yeah. We can take
5 minutes?
Yes.
Okay, so I wanted to just talk briefly about my work on the forum. So it's comprised of 16 representatives. 8 are elected by the state and 8 are Indigenous nominated. So theoretically, you'd say, well, you've got half state, half Indigenous people, so you would have a great fora to discuss and to meter out recommendations, because you have the state, because recommendations that fall from the 2 week that we sit in New York, those recommendations are eventually adopted by ECOSOC and then eventually by HRC, the Human Rights Council. So they enjoy a high level degree of consideration. And it has fallen from this fora. We have half state and half Indigenous peoples, and the recommendations we adopt are by consensus. So everyone has to agree before they go forward. So I think this is a terrific vehicle, if you like, to really tease out what recommendations should fall in terms of recognising meaningfully those rights for Indigenous peoples. We have an interagency support group that assists us. So agencies like WIPO, for instance, that I talked to at the front end of my presentation, UNDP, the World Bank, and UNEP. So we work together with those UN agencies to help realise those rights within the declaration. So my role on the forum is very much driven by Article 42 of the Declaration. So the Article 42 of the Declaration just basically says that if you're on the forum, you need to support all those rights contained in it. So that's a nice article for me to point to in terms of my role full stop. My portfolio, so each member of the forum chooses a portfolio. My portfolio is human rights, obviously, administration of justice, traditional knowledge, and the environment. The corresponding agencies I work with are WIPO, the World Bank, and UNDP. And I just wanted to mention quickly about the World Bank. I was in Jamaica a couple of weeks ago at a Climate Investment Fund Partnership Forum held by the World Bank. And it's this huge project that they're pulling together with the Asian Bank, the Inter-American Bank, and the World Bank to sponsor projects that alleviate effects of climate change, and they review applications for these projects, and they use funds from the bank, and there's this whole leveraging financial thing happening there. But what I wanted to mention there is that they actually view local communities with the same standing as Indigenous peoples. So that's kind of interesting when we're thinking about minorities, I suppose. Minorities there. Yeah. And at home, apart from being a legal academic, I'm also a treaty negotiator for different iwi or different hapu. So what that involves is representing each iwi on matters to the Crown in terms of breaches of the treaty. So you might remember at the front end of my presentation I talked about the Treaty of Waitangi, and I said it was an agreement entered in between Māori and the Crown in 1840. So in 1975, the Waitangi Tribunal was established, and that tribunal was basically to hear grievances or breaches of the treaty by the Crown from Indigenous peoples or from Māori. So I help or assist iwi groups with their claims to the tribunal to realise or to try and achieve redress for those breaches. And you think, well, this is great, you know. You have this tribunal, it's there to assist Indigenous peoples, you know, this is really terrific. But what they don't tell you is that the tribunal only realises 2 or 3% of the land that was alienated from Māori. And you know, it's incredible. And you think, well, why is it so successful? Well, it does offer a venue for airing of grievances, and that's quite cathartic in its own right for Indigenous peoples. And it offers an opportunity to pull together a lot of history and songs and waiata that have since been lost. It also offers quantum or money, I suppose. And so from those treaty settlements, what iwi do is they realise self-determination, and they develop that, and they become quite commercially astute with their investments there.
Did I understand you right when you said that the tribunal recognizes 2 or
the tribunal comes out with a report and some recommendations.
Yeah.
Eventually, recommendations aren't binding, yeah,
Yeah.
on the government, and the government say, well, okay, we'll give you we'll give you back this, and invariably, Māori only get 2 or 3 or 5% of the land that was alienated from them.
So much
Yeah.
about the land rights.
Yeah,
Yeah.
yeah, exactly. Yeah, exactly. And just quickly about the Indigenous worldview, I think that's, for me, that's really important because with an Indigenous worldview, everything and everyone is related through family tree and what we call whakapapa and whanaungatanga. So whether it's animate or inanimate, everything is related. And in an Indigenous worldview, the idea is balance, right? Balance and harmony. Once that balance and harmony is out of balance or out of kilter, so how do you bring that balance back? So you can apply that thought or that whakaaro to criminal justice offending, to the environment, or to different aspects of it. So for instance, if when there was, to bring that balance back, Māori have different regulators, what we call mana or tapu, or to try and bring this balance back. So if there is, for instance, we think about the environment, they will often put a ban or a rahui over a certain area of coastline if it's out of season, and that helps restore the resources back or replenishes the resources. With criminal offending, I wanted to just quickly mention an initiative that's currently been implemented in New Zealand, and that's a youth court held on a marae. So a marae is our traditional meeting house, and they are holding court on our traditional meeting house, and they use our culture and they also use our language, and it's really important that the offender can identify as Māori. However, in saying that, this marae court is also open to non-Māori offenders because it's a principle-based doctrine, and that can apply irrespective of whether you are Indigenous or not Indigenous.
And do they use it? Sorry.
Yes.
Would non-Indigenous use it?
Yes.
So that
Not very often.
Not very often, but practically justice.
Yeah.
Justice.
Sure.
What you call balance.
Yes.
In Māori.
Yes.
Then is established through these principles.
Yes. Yes. Yeah. Yes. It's like restorative justice, family group conferencing, therapeutic jurisprudence, tikanga Māori, balance, holistic nature. Yeah.
And this is a legitimate tribunal.
Yep. It is legitimate. Yes.
And
Absolutely.
once this balance or justice, we would probably call it justice, is established, that is acknowledged as a formal. Can criminal cases be considered?
They are. Youth.
That's amazing.
Youth.
So criminal causes can be observed or tried, and then the result is acknowledged.
Yes, it's youth offending. Youth offending only at this stage. Youth offending.
But even that, it's
Yeah.
normal.
And what happens is on the marae or on the court, they determine what the program will be to restore that balance, to rehabilitate them, or whatever it has to be. And everyone, it's a collective. So you have the families, you have the police, you have social services, you have all the community groups that sit around and discuss that. Yeah. So, yeah. And it's all about reducing recidivism, because it costs money to put people in jail, and it just makes practical sense. So finally, conclusions. So I think today, that picture I painted, that chronological timeline, you can see that Indigenous peoples have strived to recognise or have their rights recognised in the face of adversity. We have three vehicles specifically devoted to Indigenous rights within the UN. We have the Permanent Forum, the Expert Mechanism, and our Rapporteur. The declaration is incredibly pivotal to recognising those rights and as a clear articulation of those rights. And I think we've already talked about that parallel with minority rights. And where to from there? And I think that very much turns on what you want to achieve as a minority, as a minority group. And I've put in there the post-2015 goals because you know that I mentioned the end of the second decade is now up, and with that, of course, is the Millennium Development Goals. So it's at a juncture, I suppose, and it might be a nice window maybe to consider advocating for minority rights in some form. And that quick example at the very end of my presentation today about Marae justice, I think the inclusion of that Indigenous worldview can really make a difference, because if it reduces recidivism, then it has that practical flow on that the offender becomes a working part of the community. There isn't the cost for imprisonment, so let alone the whole holistic nature of it. So thank you for sitting through all that. It's been long and hot and boring. So is there any other questions, or talked you all out? Great.
There's no break because that's the last lecture now. So let's
Thank you.